Good morning, and thank you for coming this morning. The speaker who was supposed to be here was unfortunately not able to attend and that for it, so you're stuck with me for the presentation. So this morning what we're going to have a conversation on is to talk about special needs planning. So it's part of a whole kind of an estate planning area for it, and there will be another, next month's seminar will be similar as well. With a similar topic in that for it. So this is going to basically talk about some basics on it. So right now about 12.8% of U.S. residents, covering all ages, report having a disability. 5.5% of those people are between the ages of 5 and 15. 6.2 are between 16 and 20. 10.9% are between 21 to 64. And do you know why it doesn't count anybody over age 64? Because once you're retired, you technically cannot be disabled. So if you're on Social Security and you're at the age where 65 is your retirement age, Social Security disability turns over from SSDI over to just plain Social Security. Therefore, so technically you can't be disabled and retired at the same time. So the statistics are 1 in 68 American children has an autism disorder. And 1 in 10 older Americans has Alzheimer's disease. Alzheimer's is one of the fastest growing challenges that our country, maybe others, face with regard to it, and therefore so it becomes a very challenging. So what's special needs planning? So special needs planning provides for an individual with special needs, taking into consideration the needs of the family as well as the individual. So when someone goes through one of these situations, it's not just them necessarily that goes through it. One of the biggest challenges sometimes with long-term care planning is that the person providing the care sometimes actually ends up in worse shape than the person receiving it, right? Because it's a 24-hour, 7-day-a-week situation if you're the person that is providing the care, which can become very draining. And that for it, right? So it's important to have plans in place. Plans can be made by an individual or a loved one for a child, a sibling, a spouse, a parent, or other relative. So if you have a trust, and you should have a person that has special needs or that for it, you can always create what's called a special needs trust as a subset of your trust once something is executed at that point. That can prevent those assets from potentially being confiscated, making sure that the assets are used in an appropriate manner, providing for their care and providing for your estate as that for. It's not their money, it's still part of your estate, and they have a plan and everything that is set up for it. So special needs can encompass a lot of things. The goal of the planning is to balance your present and future needs with the loved one's present and future needs. Right, so what their care is today may not be the care that they need 2, 3, 4, 5, 10 years from now, right? And if you should have someone with special needs and you want that person to be taken care of and you're the primary caregiver, especially if it's a child or that for it, then you should be making provisions on how that is supposed to happen. What happens to the house, right? If they're supposed to remain in the house and that for it, right? You also want to make sure you communicate everything to relevant persons. So who's the person that's going to be taking care of it or taking care of them, right, in the situation there for it. You want to review these plans and revise them if their health situation or that should change, right? So if something should change with it, they either become worse or they improve or that for it, you can make those changes accordingly, right? And you want to assure family members that loved ones' needs have been adequately addressed. Adequately addressed does not necessarily mean just having the house there. It's how are those assets going to be funded to make sure that there's funds available to care for those people. All right. I don't know about nursing home care right now. I think right down here on Western Avenue, there's a facility. It's about $8,000 to $9,000 a month for care, right? So, and if someone's going to be there for a long period of time, that could obviously have a significant impact on the family finances and therefore, right? So you want to make sure that those are addressed. The risks of not planning ahead upon someone passing, certain decisions will be made for you, right? The appointment of a guardian or successor, conservator. So if you haven't said who you want to be in charge or who's going to take over or that for it, then the courts will step in and do so. And they may appoint someone that you may not want. Or that person that you may want to do it might not want to do it, because being a guardian requires a lot of care. You have to provide records to the courts. It's because it's a court-ordered situation and that for it. So it's not the easiest thing to take care of. And the state can determine how much of your estate your loved one will inherit. So if you don't adequately plan for it, then monies may be going to people and that you may not want to go there for it, and may not be used in the manner you want, and you run the risk of potentially then having that money run out, right? So what you need to do is basically create and implement a current personal care plan for your loved one, take an assessment for it, create a transition for continued personal care, create and execute a legal plan. So how many of you in here have your wills and trusts and powers of attorney? Okay. So if I see a few hands up and a few other ones not, if you don't have at least a will, then the state of Illinois will determine who gets your money and how your assets are going to be passed, right? So if you have a house and you don't have a will, then the state can determine who's going to get that. It's called passing intestacy, and when you pass intestacy, the state gets the right to choose. And the reason they get the right to choose is they look at it and say, well, you had the opportunity for as long as you were, so to speak, here on this planet to be able to execute what you wanted, and since you didn't care, we're going to take care of it, right? And monies and assets may go to people that you may not want it to go to, right? So if you don't have a will, at worst case, you should have one for it. If you own property, then you may want to have a trust, because a trust can help avoid the probate situation and that for it. And then the other two documents that all of us will need at least at some point in time, power of attorney for property, meaning that somebody can on your behalf be able to conduct business while you're still here, and a power of attorney for health care. So the health care power allows someone on your behalf with which to take care and be able to make sure that they get information in that with regard to it. If you, yes?
You said the word was passing and
intestacy. Intestacy. You pass what's called intestate, which means that you don't have a will in that for it, and the state gets to choose. And each state is different. So Illinois has a certain distribution plan. Indiana has their own plan. Wisconsin has a different plan. Not every state has the same plan. All right. So just if you're doing that, you want to make sure you have these documents, because not having them could end up costing your estate. May not matter to you because you're not here, so to speak, right? But it may cost your estate or cost the people that you want to get the proceeds a significant amount of money and that for it. So, yes.
You mentioned Smith Village is about $8,000 a month, $8,000 a month.
Right.
And they have an interest fee on that too, about $250,000. That's right.
They have a what? I'm sorry.
They have an interest fee.
Oh, an entrance fee?
Yeah, and that's about $250,000.
I'm not sure the cost. Some of them do. It depends on the situation. Different communities have different programs. Different ones have. So some of them are. Well, the question was about whether you have a plan if this facility charges an entrance fee for it. Some of them, basically, what you do is you can buy a condo, so to speak, or an apartment type area for it, and there's an upfront cost in that for it. Some of them will guarantee that your family will get back a portion of that, maybe not 100% of it, if they can sell it, if they can rent it or sell it out for it. There's a whole host of different areas, but that's can be part of your planning portion, right? If you want, I'm not sure if those are necessarily the best places for it. They could be because you have kind of ownership portion, but it could be that you're providing a lot of money up front that might be able to be used for other things, right? There may be other long-term care centers which are just as good, but you don't necessarily have to come up with $100,000 today to buy your unit or that for it, right? So, well, they may not be, but I'm just talking in general terms in that for it. So you just always want to make sure, and those are if you do decide you want to invest in one of those for it, you have to be very cautious on it because each one of those situations is completely different in that for it. So
Can't you stay at home and give them, say that?
you could. The question was, could you stay at home? The answer is yes, you could stay at home, but then you're paying for in-home care and that for it, which will tend to be less, but they may not have all of the equipment or the necessary medical supplies available at the same time. It depends on your situation, but that's part of your planning, right? And I always say this, is that if your long-term care plan is that your son or your daughter or your niece or your nephew are going to take, your grandson or granddaughter are going to take care of you, then you should have a conversation with them about that, right? Because that may be your plan, but are they willing to kind of comply with that plan, right? You know, if you have your son or daughter, if they have children, they may not be able to do that because they're working, they've got to take care of the kids and that for it. They may not be able to stop working in that for it. And part of that challenge also becomes statistically, the oldest female in the family tends to be the one who provides the care. And the challenge with that becomes, for them, becomes if they are providing the care, that could mean that they're not working anymore, right? Which means they're not earning any Social Security, they're not providing income to the family unit and that for it, which could cause financial hardship for them. So it's important that you do have this conversation, because not having the conversation doesn't mean that it won't happen, right? So we want to understand, if you're creating the plan, who's going to provide the care? The family or friends? Is it going to be full-time or part-time, right? Depending on where you're at in the country, those costs could continue to go up. For example, Florida has a relatively high population of retirees, right? Well, if they have a high number of retirees and they all need care at the same time, what do you think is going to happen to the cost of that care? It's law of supply and demand, right? If there's more people that need it, right? The demand's there, supply is short. There's going to be more money that's necessary for it, right? So you have to understand some of those things, and there could be shortages, right, for it. So then the question becomes, you talked about where will you live? At home, right, independently? Will you live with a family member? Is an assisted living center or that for it? Where is that for it? So if you're looking at it, what's needed? The household chores, right, are going to be taken care of. Washing and dressing. You've got meal preparation, transportation, medical, safety. These are all part of what the plan is, right? You've probably all seen those ads on TV with the little, the button and I fall and I can't get up situation there for it, right? 20 years ago, those weren't on the TV, or there wasn't much of a need for it, right? But what's happening today? People are living longer, right? I was talking with a client, look at George Bush, right, that just passed, 95 years old, right? His wife was 94 years old. Probably good genes in that family, right? More and more longevity is in, the things that used to kill us might just disable us or not, allow us to function in the same capacity, right? So if you're the create a transition plan for it, the continuity of care, and who's going to be the person that takes over that, right? Choosing alternate people and services to replace the original plan if needed. Anticipate and prepare for the future life events. We can't prepare for everything, but that doesn't mean that things aren't going to change in that for it. You have to answer the what if questions. What if I die unexpectedly, right? What if your loved one becomes unable to make his or her own medical decisions? Who's going to make those decisions? That's why it's important to have those documents. If you don't have the documents, then decisions might be made for you that you may not want to be made, right? So it's important that you have this information, because without it, things cannot transition and that for it. So part of you're creating the legal plan is the medical directives, powers of attorney, which we talked about. Having a will, right, because that's part of it. A letter of intent would be recommended that you speak with an attorney, right? So the attorney can help walk you through these things. But before you sit down with the attorney, you really need to make a list of the things that you want to be accomplished by your will or your trust. So if your will or your trust, if there is somebody that needs to be taken care of, you need to make sure that you write down what you want done before you go and see the attorney. Because the hourglass starts running as soon as you walk in, right? So you want to make the best use of the time that you're going to be there for it. So if you can provide them with what you want done, ahead of time, then they can at least put it into the perspective and everything that you wanted, right? You have to create and implement the financial plan. So just creating the documents doesn't mean they're implemented, right? So a lot of times people will create a trust, but they won't fund the trust. They won't put any assets into it. That's a problem. An unfunded trust is not considered a viable asset. It's not considered a legal asset because there's nothing in it. It has to be funded before something happens to you in that for it.
Excuse me,
Yes,
how do you fund it?
you can title your house into the trust. Now it's funded, right? You can have a checking account, and the checking account is entitled in the trust's name. Now the trust is funded, right? So that's how you fund the trust. You put assets into the trust, be it a house, cash, investments, savings accounts, CDs, whatever the investment area would be. Then the trust is considered funded. Sometimes the attorney, when you're meeting with them, you'll see on a lot of them that they have $10 that was given to them to fund the trust. Now the trust is funded at that point. If they don't do that, then there's always a problem with it. If you do meet with an attorney and you're talking, you have a house and you want to have your house titled to the trust, then it's recommended that you make sure that the attorney is going to complete that task. Some attorneys will draw up the documents and they'll tell you what needs to be done, and then it's up to you to do it. Well, I don't know about you, but I don't know much about retitling my house to a trust or that for it. So a lot of times what happens is the attorney gives you the list of things to get done, and they don't get done because we don't have the expertise with which to do it, right? So if you do meet with an attorney and you're having a trust drawn up and that for it, then it's recommended you ask the attorney, are you going to be the person that's going to retitle the house to the trust? If the answer is yes, then you just, you'll fill out documents to do the titling for it. If the answer is no, then the question to him is, okay, how do I go about doing this? I've never done this before, right? And in Chicago, to get your house titled or to do the quick claim on it, basically there's two documents that are needed. The Cook County in Chicago, they like to collect money, so they get two documents. Cook County has their own document for retitling, and the city of Chicago has their own document. If you are out in the suburban, if you're not in Chicago, then you only have the county document to complete at this point in time. So, but you want to understand that. You want to understand what the attorney is going to do, because if he's not going to do it, then who does it fall incumbent upon to do? You, right? So, and it's always good to go through and make sure what you want done is part of everything that's there for it.
Well, wait a minute, when you say it's like retitle,
Mhm.
you say it's like retitle, okay? So I'm retitling in my daughter's name? What-
No, so if you have a trust, for example, and the trust is titled, let's say, in your name or you're in your spouse's name in that for it. If you go to the attorney, you draw up a trust in that for it, then they complete the paperwork and the house gets retitled to the trust. So it's the revocable living trust of Milton Flanagan now owns the property. Technically, I don't own the property. I'm a trustee of the trust and I can make decisions upon the property, but I don't own it. The trust owns it. So therefore, it avoids probate. All right. So that's how it gets. That's how you get the title and that changed for it. Okay. So you also have to look at projecting for inflation, right? I mean, inflation for most people in general population is right now running around 2%, right? As we hear concern about inflation. For those people over age 65, it's significantly higher, and the reason is medical costs. One of the reasons, right? Medical costs continue to increase exponentially, right? They're not typically going up by 2% in that form, right? Look at your Medicare costs for next year, right? Medicare is going to go up next year because you got an increase in Social Security in that for it. Medicare Part B premiums are going to go up to roughly about $136 a month, which is about a 1.5% increase. Right? So now you've got your 2% there. That doesn't take into account your co-pays or anything else that you would have to deal with.
So let me just say this, you know what I think is unfair? Is the fact that you don't get Social Security, but yet I'm still gonna be penalized with my Medicare going up.
Well, Medicare is gonna go up as soon, the only way Medicare can go up is if they have an increase in Social Security benefits. So the years that, because there's what's called a hold harmless provision inside Medicare that says Medicare cannot increase its premiums any more than what Social Security increases their cost of inflation. If Social Security is not increasing If you're not getting an increase in Social Security, then you are not going to see an increase in Medicare. Yes?
But what about if you don't get Social Security? It should be zero.
Well, but Medicare continues to increase for it if you're going to continue to receive it. Yes?
You said that 1.5% Social Security is going to increase?
The Medicare premium, about 1.5%.
If you're paying, let's say, $500 a month now, 1.5% of that is not $135.
Medicare Part B. Your Medicare Part B well, it depends on how you're receiving it. If it's being administered through Medicare, or if it's being administered through, like, did you work for like the county or the city or that? Okay, so what's happening is at that point in time, they've shifted everything over to Medicare to pay for it. You didn't pay for Medicare Part A while you were working. So most of the people paid into Medicare Part A the whole time they worked. That's why Medicare Part A is free, so to speak, when you get over 65. If you didn't pay into it, what happens is your cost could go up because you never paid into that portion of Medicare. So there's a whole, we go into more detail on it, but it does get rather complicated on how it comes together and that for it. Because it used to be handled through the city or the county and that for it, and they shifted everything over to Medicare to basically implement and take care of everything for it. So you may need to look to preserve government benefits, right? So having assets titled correctly and having, let's say, a special needs trust or something created, that may allow your beneficiary to continue to receive benefits, right? If you don't set it up appropriately and they receive the money, then those proceeds could potentially be used with which to spend down again and pay for their care and that for it. So it's important that you take care of these. Sources of government benefits tend to be national organizations, community aid, state aid, and or federal aid, right? So Medicaid, a lot of times people are on that need these. Federal benefits not based on financial aid, Medicare, Social Security, and other benefits including special educational assistance. Federal benefits that are need-based are Medicaid. That's obviously a joint and the feds fund it, but the state administers it for it. Then you have supplemental Social Security, SSI, provides income to people age 65 or older who are blind, disabled, or have limited income, and that for it. Some planning techniques. Certain techniques are permitted by federal state law to maximize available resources. Government benefits are available to all families regardless of their means. Families can use their personal resource to provide for non-basic needs, and families' personal resources serve as a secondary source of things. Special or supplemental needs trust. Special needs trust or supplemental trust in SNT gives official legal status in 1993. If the assets are properly drafted, it will not be counted as available assets. All right. So that's you'd be part of a Medicaid planning program from it, and the trust disbursements are not counted as income for it. The self-settled or first-party trusts created for sole benefit of an individual with a disability under age 65. They're created by a guardian or a grandparent for it. They cannot be created by the individual, obviously, because they don't have the capacity for it. And the individual with a disability can fund the trust. One of the advantages to this is that it avoids Medicaid and SSI look-back provisions, right? So you're not having to deal with the 5-year look-back issues for it. Assets in the trust are not countable as resources for eligible purposes, and upon the individual's death, any money, assets remaining in the trust may be used to reimburse the government for Medicaid benefits for it. So those become used. If you look at pooled assets for it, they're managed by a nonprofit organization. Funds are pooled for investment purposes. Sub-accounts are maintained for each beneficiary. It can be created by the individual or pay back to Medicare for help pool, depending on the state's laws. ABLE accounts. ABLE accounts are tax advantage accounts, similar in some respects to 529 college savings plans. It's available to individuals who began disability before age 26. The account's funds will generally not count toward the personal asset limit for Social Security or Medicaid. ABLE programs are operated by the states and details vary. Eligible individuals may have only one account, so you can't have multiple accounts with it. And the contributions are made with after-tax dollars. Any earnings are tax deferred, and the distributions are tax-free when used for a qualified expense, just like in a 529 account. There's no federal income tax deduction, but states may offer tax deductions on their own, and there's an annual or a lifetime benefit contribution for it. So kind of wrapping things up with regard to this, if you have a loved one who has a disability or that form, then and you're concerned about his or her future and financial security, then it's important that you start to think and put documents together for it. Right? There are reasons why people might create separate trusts, why a husband and wife might have two separate trusts. It could be to start to divide assets out if you're starting to do planning and that for it, right? Because if the assets are in a certain one person's trust, that means they're not necessarily the other person's, right? So if that's the case, then those assets could potentially be exempted from a look-back area, that for it, right? If you're concerned about meeting both your and your loved one's needs and your own, how is that going to happen, right? How is that going to be taken care of? Again, things that we need to take a look at for it. So when you start to look at the planning aspect for it, it's more than just what do I have available and what's here. It has to take into account the whole picture for it. You have to look at how assets are titled. So many times people will tell me that asset titling doesn't matter. And my response is titling doesn't matter until it matters. And once it matters, it's too late. Because once it matters, I can't do anything about it. We can't retitle assets. We can't put beneficiaries on accounts. We can't do anything at that point in time. Right? So I have a client right now that's going through a situation where they don't have beneficiaries on accounts. The beneficiaries they do have on accounts those beneficiaries are no longer alive. So if you have not done a beneficiary review, then it would be advisable to do so. Right? Having beneficiaries who are alive, right, that will prevent any probate. If you have a trust, you can make the trust your beneficiary, and the trust can act as a conduit to basically distribute those assets and that for it, right? But it's important that you go through and you look and evaluate each one of these, because if you don't, again, the state of Illinois will be more than happy to go ahead and do it. And not only will the state of Illinois be happy, guess who has to assist you with your estate with that process? An attorney. And the attorney will be very happy to help you because typically their reimbursement, their cost is generally anywhere between 2 and 10% of whatever they are probating. Right? Could be more. Each situation, they're individual business people. They can run their businesses however they want. Right? So it's important, if you would like to try and preserve those assets, then it's important that you go ahead and you put plans in place to do so, right? Once you do them, you don't necessarily have to go back and do them again, with the exception of your power of attorney for property. So power of attorney for property, some organizations, some financial institutions will not accept the power of attorney if it is stale. And by stale, some companies it's within a year. Some companies it's within 3 years. Some companies it's within 5 years. If a client comes to me and they have a power of attorney and it's not a newer document, I am very hesitant to accept it. And the company is as well, because if we're dealing with your money, we need to make sure that the person who is working with it has the legal capacity and authority with which to do so. And some people walk in with a power of attorney that's 10 years old, and it'll be like, okay, I don't know about you, but a lot's happened to me in the last 10 years, and that for it. We want to make sure that the person that's going to be executing on your behalf is the person that you want to do so. Yes?
That long-term care insurance, and you have that insurance, and all of a sudden the person that got that insurance on died. What happened to the policy?
So the question is with regard to long-term care insurance in that for it. What happens if someone passes and they haven't used any of the benefits in that for it? Depending on the policies, it's kind of like your homeowner's insurance, right? You have homeowner's insurance, hopefully that you don't need it, right? But if you should need it, it's there, right? So long-term care, traditional long-term care insurance tends to be like that, in that if you have a policy and you don't use the benefits for it, then that just kind of goes away in that for it. Some of them have a situation if you've been paying in for 10 years or longer, and it's a joint policy for yourself and your spouse, then the spouse's policy may be paid up. Different companies have different rules with regard to long-term care policy. Today, there are a lot of different ways to be able to potentially get long-term care insurance. There's a traditional way for it. The challenge on those has been, over the years, they have been underfunded from the cost standpoint of what the insurance company thought costs were going to be, and the number of people that were going to use it, and the number of people that were going to keep it. So what you've seen in some of those policies is that they have actually gone up in cost, or they've sent a letter and said, we're going to reduce your benefit, keep prices the same, and that for it. There are life insurance policies today which can now provide, in some instances, chronic care. When Bill was in last month kind of talking about, you know, how the life insurance can help provide for long-term care needs and that for it. There are some other policies, other options out there where you could potentially do a larger sum up front to be able to provide a benefit. But a lot of them have two components that you have to really think in terms of. One is going to be your age. So some long-term care companies are not going to write above a certain age because the propensity that you might need the coverage might be tomorrow, right? So you might be healthy today if you're 90 years old, and you might be able to run a marathon, but you know, you're not buying a lot of green bananas at that point, right? So you may not be in a situation, and they don't want to take the risk for it, right? So different policies and different programs have different, you know, contingents on it. You just need to make sure you're aware of it.
Well, what company was he with?
He was with Penn Mutual. Penn Mutual, right? So, any questions? Yes. I'm sorry.
To avoid having a stale power of attorney, are you suggesting that it be reviewed on a...
Review. I would review if you have a power of attorney. So there's two ways in the power of attorney. If the power of attorney is on a document already, then the company isn't going to look for another one because you're already on the checking account, you're already on the life insurance, you're already on the annuity to get information. Then that's fine. You don't need to redo it. But if you have a power of, a lot of people will get powers of attorney, they'll kind of keep it away because they don't want the person, they're afraid the person's going to want to try and take any money out of the account or that for it, right? Well, if that's the case, then you should probably review that every 3 years, right? Because if it becomes stale, people may not accept it, and it's the time when you need it, it may not be available for it.
Another question has to do with funding the trust. Isn't there some language, a catch-all or umbrella language, that will allow the trust to be funded with items that have not been specified?
It can be done, but you have to have the trust funded before those items can be added to it. So a trust has to have like $10 in it, right? As long as there's an account, as long as some assets are in there, it doesn't have to be a large asset. It just has to have something so that they know the fund is alive. Because technically what happens is that the trust is, if it's a revocable trust, it's revocable while you're alive, right? Because you're here to make those changes. Once you pass, it becomes irrevocable, right? And once it's irrevocable, nobody can make changes to it because you're not here to make those changes, right? So in order to be funded, it needs to be funded while you're still here, unless it's already established as an irrevocable trust, which you would have assets in that for. So, yes?
I heard you mention that if an asset didn't have a beneficiary, something should happen, the state would intervene, right?
It could be right. So if you could step in and have because you died without a will, the state would step in and it would pass what's called, it would go through probate and it would pass through intestacy.
If you have an investment, you have a beneficiary. For the most part, it's taken care of. So
As long as the beneficiary is alive at the time of your passing or that for it, the answer is yes.
okay. So in that case, you wouldn't need a will or anything else.
Correct. You could, because as long as you have beneficiaries on your accounts, there's no probate. Because then, think of it in these terms, the bank or the insurance company knows with who to send that money to, right? So if you're going to have an individual be a primary beneficiary, and let's say it's just one individual. So I'll just use myself as an example. My wife is my primary beneficiary. If something happens to me, my assets go to her, right? But what happens if something happens to both of us, right? So I have our children as contingent beneficiaries. So if something happens, God forbid, to both of us at the same time, I don't have to worry about a probate situation or anything like that because I already have my children listed as beneficiaries on the account. I'm not saying you should do that. I'm just saying that's what I have done, right?
Okay.
If your trust is a beneficiary, you don't need to worry about a contingent because the trust can live on forever. And Benjamin Franklin's trust is still being implemented today, 200 and some odd years after his passing, right? So if you have the trust has longevity. The trust is almost like a corporation, right? So therefore you wouldn't have to worry about a contingent. But if you have an individual as a primary for it, you know, and that's where a lot of times problems happen is that, let's say I had only had my wife down as primary for it, no contingents listed. Something happens to her before me, and then I never changed the beneficiary. I've now created a probate, at worst case, at best case, a probate situation. And if I don't have a will, I've not only created a probate situation, but I've created an intestacy situation, right? So that's why it's important to have the documents completed appropriately, right? That's when people say it doesn't matter, I'll get to it later. Well, getting to it later, yes, that's fine. And I will just give you an example. I had a client once who came in, he had an IRA account. We made some changes to the IRA account, came to asking him who he wanted as the beneficiary. He said, oh, just put my estate down on it. It's not a problem. I said, well, he was married at the time. I said, well, if we don't have an individual, if you know if something happens to you, this could be a problem. He said, oh, nothing's going to happen to me. Don't worry about it. I said, okay, you know, it's his account. He can put on there who he wants, right? Well, unfortunately, he went through a situation where in about a month he passed, right? His wife comes in thinking she's the beneficiary and says, I'm here to fill out the paperwork for my husband's IRA account. And I said, well, I can't let you do that. And she's like, why? I know I'm the beneficiary. I said, no, you're not. She's like, well, why did you let him do this? It's not my account. It's his account. If he can put on there whoever he chooses to have on there for him. He had his estate, and he didn't have a will. So now we had the problem where she had to probate. It was just the IRA account because all the other assets were joint titled. Just had to probate that IRA account and had intestacy on that account. It cost her, it was about a $200,000 IRA. It cost her about $12,000 to probate just that asset, right? Just that asset. No other assets were in there. Now, I personally think the attorney may have taken advantage, but that's my opinion in that part, right? But if you don't want something like that to happen, then you make sure that you have the appropriate beneficiaries listed for it.
Okay, now, okay, I'm not married, okay, so let's say that I put my daughter on as my beneficiary on my trust, okay?
Is in your trust, in your trust, you would be a beneficiary, okay?
Okay, well, she would be, okay, that's what I'm just saying. I put my daughter as the beneficiary on the trust.
Your daughter could be a beneficiary inside of your trust, and she could be a successor trustee as well.
Okay, well, this is my question, like, now, if something happens to her, can I put my granddaughter,
Sure.
who's 8 years old, as the contingent?
You could have her as a contingent on it, but what I would also do is specify who is supposed to look after her. Because if you don't, then the courts can specify up until age 14 and a half. At 14 and a half, if something happens, and so let's say I had my daughter on my account, let's say she was my beneficiary, something happens to me and she's 8 years old, right? From 8 until 14, she could, let's assume my wife was there, right? For some reason I had my daughter on there. My wife could be in charge at that point. 14 and a half, she gets the opportunity to change if she wants. So, because that's where the kiddie tax rule comes into play. So at 14, if somebody passes and their child's 14 on it, and they don't like mom anymore, and they want to put a boyfriend or somebody that's 18 or older on the account, guess what they can do? So if you're going to do something like that, my suggestion is that you would say, okay, if this person isn't going to be there, then I want Auntie Susan to do it, somebody else, right? That's going to look after the person, and since it's already listed there for it, then they would abide by that information. Yes?
When you have a transfer on death for your house and beneficiary, do you still need a will?
You should. The question is, if you have transfer on death on your house, should you still have a will? The answer is possibly, Because unless you have beneficiaries on every other asset that you have for it, on your checking account, on your savings account, on a CD, then if you don't have a will and there's no beneficiaries listed, then you would potentially have intestacy depending on the value of those accounts and that forth.
But on the transfer of that means whoever I have listed
Would receive the asset.
will receive it.
Correct, without any probate. Yes.
Now, funds that you don't have in a trust, as long
For your
as
house. You don't, oh, I'm sorry.
funds that you don't have in a trust, as long as you have a beneficiary on those funds, it's okay as far as.
As long as the beneficiary is alive at your passing. Correct? I mean, if the beneficiary is passed and then you pass for it, then who's the asset supposed to go to?
They can also go to charities also.
Sure, you can have whoever you want as beneficiaries. I mean, it could be church, charity, family, friends, your neighbor. I mean, me if you want. I mean, but but I mean, but you want to make sure. Again, that's why you might want to have contingent beneficiaries listed, or in some cases, some will have a check mark that says on a per stirpes basis, which means that if something happens to, let's say something happened to me, it would follow my bloodline and go to my children or that forth. So if you have that, if it allows for a per stirpe situation, even if that person were to pass, then it would go to their children or that forth, right? But that's why it's important to look at these, right? A lot of times people just get these documents and they go, oh, it's no big, I'll just fill it out later, it's not a big deal. Well, it may or may not be, depending on the situation, right? That's why it's important to go through them. I'm not saying you have to go through these every week or that for it, right? But if you should review them periodically. How many of you have a life insurance policy that you looked at in the last 5 years to see your beneficiaries and make sure everything's updated? Where's the life insurance policy at? Most likely in the safe box, right? Or in some place where you never look for it, right? Well, it might be advisable to review that. It might be advisable to make sure, right? You can't think this is what's on there. You have to know what's on there, because when it gets executed, if it's not what they know, then guess what? It doesn't happen because it's not what you wrote, right? And if you know somebody who is going through a divorce or that for it, and they have life insurance, you might want to ask them to change the beneficiary. They may want to change the beneficiary on their life insurance, because if something were to happen, those proceeds, court cases have proven, will go to the person that is written. It's a legal contract between you and the life insurance company. If you say you want your ex-wife on there and you're remarried, right, guess what happens? The new wife thinks she's getting it. The ex-wife gets it. Might not be for a happy situation. But you might not care because you're not here. So,
What is the approximate cost to develop a will?
So the question, what's the approximate cost to develop a will? Depends on the attorney, but typically if you're doing a will, a trust, and the powers of attorney, the cost can be anywhere, the range maybe from $2,000 to $5,000, depending on how complicated you want your trust or that to be for it, right? And once you do your trust, you don't necessarily have to do it again. Right? You can amend beneficiaries if you wanted to in there for it, but you wouldn't have to rewrite the whole trust. You just amend certain sections.
I said will, not trust.
Just to do a will, attorney, you're probably talking maybe like around $500,000, something like that for it, depending on how complicated you want your will done. But you may need more than just the will. You may need powers of attorney. Even if you decide not to have a trust, you may want to have powers of attorneys on, right? So you've got a healthcare power set up. So somebody's in charge in the event something were to happen.
Elderly law and disability work with seniors, and they, depending on your income, it could be free, or they much cheaper than regular attorney. So if you're elderly law and disability, I don't have the information with me, but I went to them and mine was free, because a certain amount of money they don't charge.
Yes.
And then could you also explain, transfer on death?
So the question is about transfer on death. Transfer on death is a beneficiary listed on the account. So it can be a transfer on death, it can be payable on death. Those are typically how accounts have beneficiaries. So a lot of times if let's say you have a savings account or a checking account, if you look at those accounts and it's titled in just your name with nothing below it, most likely you don't have beneficiaries on the account. If you get a statement in and it says Milton Flanagan on it, and then below it says POD or TOD, it won't list out necessarily who those beneficiaries are, but by looking at the title on that statement, I know that there are beneficiaries listed. I don't know who they are, right? But I know beneficiaries are listed. So when you look at your accounts, if it doesn't have a POD, payable on death, or a transfer on death listed there for it, then there may not be somebody listed on the account. Some banks and some institutions don't put that on there. Most of them nowadays do. If it's a trust, it'll say your trust name, and it'll say who the trustees are typically on the statement and that for it, right? Each bank may be different in that case, but those are ways to be able to see if accounts have it. I can tell as soon as somebody gives me a statement, if they've got a brokerage, just a regular non-IRA regular brokerage account, and they hand me the account, I can tell in 30 seconds whether it has a beneficiary, because I'll just look down at the title on it, and as I'm reading across the title on most brokerage account statements, it will say TOD, if you have a beneficiary. Yes?
What about ITF? I've seen that on some.
I'm sorry?
ITF. I've seen
In
that.
trust for?
In trust.
It's in trust for, there's been a trust created for, let's say me, right? So it's your account, ITF, it won't say the person's name on there, but it's in trust for, it's kind of like, it's the same thing as a beneficiary.
Since wills have to be probated, would you recommend a trust rather than a will to avoid that?
So the question was, should you have a will or a trust? Usually they're done in concert. So if you have a will done, usually what's created is called a pour-over will. So if you don't specifically say something in your trust that should be in there, it'll essentially pour it over. It'll take it from the will and it'll put it into the trust, so the trust can distribute it. So typically, if an attorney is drawing up a trust, they will typically draw up what's called a pour-over will. The will may be very basic. It could be very complicated, but it could be very basic. That just says anything I haven't specified, just put into the trust, right? So then, at that point in time, everything's directed to go to the trust at that point. So yes.
You were saying something about a 14-year-old daughter. The guy dies, and the money goes it could go to the 14-year-old daughter, not the wife.
Well, if that's the beneficiary, I mean, if the beneficiary is the 14-year-old or 15-year-old daughter at that point, right?
But then could you put in there, the mother's still alive, the mother?
Potentially, you could potentially put them that they should manage it for the daughter and therefore. I mean, so there's all. That's why it's important to kind of review these things if you have these situations, right? But I mean, in most cases, it's typically the spouse for the other spouse's primary, right? And everybody usually does the primary. Nobody ever usually thinks about the contingent, right? But if you do it at the front end, then you don't necessarily have to do it on the back end, right? And if, God forbid, something were to happen at that point to one of the other spouses, there's already somebody listed. So even if you don't update the beneficiary, there's already been, you would have to provide, obviously, a death certificate to show that person is passed, and then they'd be able to go from there. Right? So there's always something to look at to make sure. Again, it doesn't matter until it matters. Once it matters, it's too late. So.
Regarding the fees associated with the wills and trust, with the trust, you pay that, whatever, 1,000 or 2,000, whatever it is, you pay. Then there's an annual fee associated with that.
So the question is there an annual fee? It depends on the trust. So if it's a revocable trust, the attorney is drawing it up, then it's typically a one-time trust, it's anywhere between, let's say, $2,000 and $5,000, right? If it is a land trust, right? So you have a land trust for it, then typically what happens is the attorney writes the trust. You have someone like Chicago Title, maybe one of the local banks that does trust work or that for it. They hold the trust, right? And then every year, so they may charge you $500 to establish the trust and that for it. Then there might be an annual fee of $100 or $150 a year to keep the trust intact, right? And then the trust is funded, the house is in it, but it's only for the land, right? You can't have that trust own your checking account. It's a land trust. It's specifically for that property. Yes?
How do you define a land trust? Are you talking about the house?
For a house or property in another state or something like that. It's land. It's physical property, and therefore.
So it could be a lot or a house?
Could be, sure. You could have farmland, right? Could be in a land trust. I wouldn't recommend that, but you could, right? Therefore, so I had handed out a blue sheet to everybody a little bit earlier for it. So recently I was at a conference, and one of the questions that came out of the conference was, do people really know what you do? And so I said, well, I do a lot of different things in that for it, right? I mean, and there's like, okay, well, do people understand what it is you do? So I came back and started thinking about what is it that we work with clients on, right? What are the different areas that we try and do? Obviously, we do the seminars and that for it, but what are the different areas for it? So we came up basically looking at kind of unique competencies. What are the things that we do that people may not think that we do for it? So the first one on there, time and purpose planning, right? The strategy discussions and that for it. As many of you have heard me talk in the past, whenever you start looking at investments, it's in terms of when you're going to need the money and what's the purpose behind the money. Once we determine that, then the investments can kind of fall back into place. Comprehensive estate and legacy planning discussions, we've kind of had a lot of that here today for it. Pre-CANA financial consultations. Memory money investing. Memory money investing tends to be something, let's say you want to take everybody to, rather than leaving money for them, you want to take everybody to Disney World, right? So you've got money that's invested for that particular memory, or that for it. Second opinions. Tax smart investing and distribution methods, next generation financial planning, right? Trying to get the next generation set up for it. Not what you make, but what you keep approaches. So trying to look at taxes and different areas, avoiding probate, some of those things that may be important to it. And then retirement strategies that include, Social Security claiming considerations, things you may want to think of about when to take Social Security and how to do it. Defined pension benefit plan organization approaches, optimization approaches. In service, so if you're 59 and a half or older, you may be able to transfer money out of your 401k, 403b, TSP. The question there becomes, can you afford another 2008 loss of 50%, right, as you're getting ready for retirement? You may or may not be able to, depending on your situation. Preserving retirement income, right? Again, you want to know what's coming in for it. Utilizing investment options that could help you achieve retirement income objectives. Determining when, how much can I. Prognoses. Medicare, what you don't know could cost you, depending if you have significant income. You could get hit with a Medicare surcharge or that for it. Required minimum distributions, how to potentially take advantage of those. Developing and implementing successful long-term care plan strategies. We talked a little bit about that today as well as implement short, medium, long-term financial strategies designed around your family's specific situation. Everybody's situation is different. If you have businesses, we talk about developing and implementing business continuation, charitable foundations, as well as written financial strategies. So this gets to basically just be kind of, this isn't everything, but it gives a good comprehensive kind of view of the different things that we work with in trying to help clients achieve their financial objectives for it. All right. And the objectives are more than just what happens with your finance, because it takes into account what the money is really meant to do for you and what the purpose and how do we potentially minimize taxes and some of those areas for it. So those become very areas. So if you know someone that would need some additional information or they'd like to have some consultation, please feel free to have them give me a call. So a couple other points here before we finish up. So everybody knows that the city of Chicago has a pension problem, right? If you don't, is this news, right? So right now they're underfunded by roughly $68 billion. So there's an article in the paper a couple weeks ago that talked about Rahm Emanuel's recommendation, or what he wants to do before he leaves office and that for it. So how many think that the city of Chicago is in great financial straits? Okay. So his solution is that he wants to borrow another $10 billion to basically for pension obligation bonds to basically put into the pension. When I read this, my first thought was, okay, so let's just look at the numbers real quick. Let's say that they have to pay a 6% interest rate on the loan, on the bonds. Maybe it's 5%. Let's just use 6, right? That means that's $600 million a year in interest that has to be paid, right? So if it's $600 million a year, last time I checked, the city of Chicago didn't have an extra $600 million laying around. Maybe they do, I don't know. Maybe they do. So if they don't have $600 million laying around, where is the $600 million going to come from? Revenue generating activity, right? Or taxes, as they like to call it, right? So it's, I mean, if you think of it, it's just kind of charging up one credit card, right? And we're just going to use it to kind of pay off the other card, but we didn't pay off the other card. We still have the other card fully, she maxed out in that for it, right? So, and that's just the interest on it Typically, they would set up a sinking fund or that for it to help do it. If they set that up, case, you're probably talking close to $1 billion a year in that for it. So they don't have an extra $600 million. They can't pay the pensions out for it. Anybody live in Chicago? Can you say property tax increases? I'm not saying that's going to happen, but isn't that where they usually try and get the money from? Yes.
Now, I mean, with the new mayor coming in, and of course, I don't know about him saying J.B. Pritzker, hopefully I'm just saying that maybe that's he's the lesser of two evils. The two evils that was running, but the thing is that, is it possible that we could be helped out if the mayor or the governor puts in the more progressive taxes? So then these banks get taxed, so then these rich people get taxed.
So the question is about progressive taxes. It's a false. It's a fallacy. The state of Illinois' Constitution does not allow for progressive taxes. So in order to change the tax system, you would have to change the Constitution of the state of Illinois. That ain't gonna happen, okay?
So the rich just will be keeping their.
Well, the rich are gonna leave. They've all left. Everybody's left. Banks don't pay taxes. Corporations do not pay taxes. Everybody thinks corporations don't pay taxes. They write a check, but if you buy a computer, who pays the tax? The individual that bought the computer, right? Because the tax is built into the price of the computer, right? The bank, whoever, if they're making this paper, right? The paper doesn't go, okay, well, we're not going to include our taxes in the cost of the paper, right? They got to pay it. So Merv and I were having a conversation. You mind if I? So we were talking. He called me up and he said, "What do you think about it?" I thought Rauner would win just because who could vote for who? If you did vote for Pritzker, how can you vote for somebody who evaded paying taxes and telling you that you don't pay enough? I have a problem with that. That's just me personally. I have a problem, right? So if you look at it in these terms, what I think is going to happen is, how many of you remember back when the state of Illinois income tax went from 3% to 5%? Anybody remember that? Okay. So does anybody know, everybody knows why it went to 5%, right? No? Okay. So the reason it went to 5%, at the same time that was happening, the federal government gave a 2%, 2 full percentage point reduction in the amount you were paying into Social Security. Roughly 90 some odd percent of the state works in the private sector, right? The people that worked in the private sector, it didn't cost them anything, right? Because instead of giving the federal government stealing 2% of my money, the state of Illinois stole it, right? So I didn't see it where I was put, where the idea was I was going to have 2 percentage points more in my pocket to be able to spend to help the economy, right? That was the whole idea behind it. Well, guess what? I never got it. The state of Illinois stole it, right? So that happened for a couple of years, and then I finally caught up to what everybody else is. So if you worked for state, county, municipal, what don't you do? You don't pay into Social Security. You got hit with the full 5% immediately, right? The other 2 full percentage points increase, right? That's how they scammed the system to be able to get it, right? So we fast forward to today, right? There's a federal tax credit. Federal taxes went down, right? Everybody's aware, 2018, there's a tax reduction, right? So what I think is going to happen, my personal opinion, okay, is that they're going to do the same thing they did with when Social Security did their cut. People right now who are working are starting to see more money in their paycheck because they've got less money that they have to pay the federal government, right? I personally think the state of Illinois is going to raise their taxes because they can't change the Constitution overnight, right? So what they're going to do is they're going to go from 4.9%, I estimate probably 6 in 2019 and 7 probably in 2020, right? To try and capture more of that. And it's going to be like cooking the lobster, right? Put the lobster in the pan and it's cold water and you turn it on. You know, the lobster doesn't know that he's getting cooked until he's already cooked, right?
Okay.
Right? It's going to be the same thing where if I'm working and instead of me paying in and I only having to pay let's say you're taking $1 from me, right? Well, now I'm only getting, let's say I'm only having 50 cents withheld because of the tax savings. Well, the state's going to come in and take that other 50 cents, and it'll be the same as what it was before. And then they'll try and tell you that you didn't get a tax cut, and that for it, right? And so I personally think that's what they're going to do. My personal opinion. I'm sure that they've already run the numbers and already have everything figured out on how they're going to jack taxes. Okay, and if you think that's bad, anybody listen to? There's an article for Bill Daley. You know, he's one of the Daley people, right? He's running for mayor, right? So here's what Bill Daley says, and if you're in Chicago, you should hold on to your wallet very tightly, because he said, in quotes, "We must find new revenues." Now, revenues mean taxes. Okay, can they tax air? They might. You know, so Daley's already told you that he is looking to get more revenues, right? And if they borrow $10 billion, they've already got $600 million that they've got to figure out how, roughly, let's say, an estimate, that they've got to figure out how to cover, right? Anybody see a problem here? Did anybody hear him say we're going to have to reduce or use assets more efficiently? No, we have to find more revenue, right? Means more taxes. So he says he doesn't want to raise property taxes. Nobody wants to raise property taxes, right? Just kind of what happens with it, right? So you're going to see, my estimation, in Chicago, you're going to see more taxes. If there are more taxes and your income is not going up to cover those taxes, right? What is happening to your standard of living? Going down, right? So it could be advisable to, if you have other assets that are available, to look at those and how those might be able to generate income to help cover some of these potential increases that they're telling you that they're going to have, right? I'm just reading it out of the paper, right? If you borrow $500,000 from the bank, you got to pay them back the interest at least, right? Well, if the city only pays back the interest, they've got to pay the interest. Where is that money going to come from?
We'll give it to him.
You know, so there's other things that Daley says that he wants to do, which would affect the state, which will never happen, and therefore, in my opinion. But these are real issues that are going to hit next year, right? The state budgets. What I think the state will also do is they'll make the taxes retroactive. They'll make it back to January 1st, so that they will collect a whole year's worth of taxes starting immediately. My opinion again. But that's kind of what happens when you get those people. Any questions? Huh? Well, I wish you all a Merry Christmas and therefore and a Happy New Year. We will have a seminar in January 3rd. We will do it for next year, starting January again. So we look forward to seeing you then. If there's other questions, anything we can help you with, please just give us a call. Thank you very much. And I do have somebody wants